over here, me and you came on together. Yep, I thought it came on. And then Jared came on 4 years ago. But I did 2 years to fulfill some guys, and then I did 4 years. But my 4 years after this 8. It's fine. It says 4 years. What year did you start? 16. And I did 2 years to fulfill some of these. And then in 18, I started a new one that'll be fulfilled. It's coming April. Which means I can do 1 more full year if I choose. And Jen started before me, but she was on a different time frame because she was doing a 3-year and I was doing a 2-year for her. I just found these behind my every time trying to do this job. Oh, here's a guy. It was one of those training things which I'm way behind on. I'm like 2 years behind. I know I'm just 2 years behind. I didn't know about a couple of years to get 4 hours in or something, but I know I'm really behind. You could like go places or good help us. You're all about ready. Get some videos and you go down to just watch a video and you can watch it. Is it like a good? Almost. No, it's like a webinar. Wouldn't surprise me. But some of them were interesting, like on the whole, like, overall planning and how to do things. Some of it was in one way. See what? Jay just said, how big damn is bigger than them? Okay, sure.
If everybody has signed that plans to speak, sign at the podium. All right, we'll get started. This is calling the meeting to order for the Scott County Board of Adjustment meeting for December 2nd, 2021. Order of business is approval of the November 4, 2021 minutes. If you've had a chance to read them, I'll accept a motion.
I've read them. I'll make a motion that we approve the November 4th, 2021 minutes.
I'll second it.
Janet and Sonia. All those in favor of approval of the minutes, say aye.
Aye.
Then we'll move along. Mr. Perkins, would you like to swear in those individuals that
I
have?
would love to, Madam Chair.
Thank you.
Everyone signed in to speak tonight. If you stand and raise your right hand, please. Do you swear or affirm the statement you're to make tonight to be the truth to the best of your information and belief? I do. Thank you.
All right, we'll move right on along to the old application for S 2021-29. Hello.
Thank you. Hello. I was going to start the process.
Okay.
This is a two-part, there's 2 parts to this application. One is an appeal of my zoning letter. And I'm Joe Kane, the Director of Planning and Zoning. I don't think I've met you, Rachel, and Kim, I haven't seen you at a meeting, so that's who I am, just to get that on the record. So there's 2 parts to this application. I think 4 of you were on the board when it came before you last. But this is a use that's been in place since for over 10 years. But in 2014, it's a landscaping business. We brought them to you for a conditional use permit because we got a complaint that it was operating, illegally It was, they were on a site that had been used for business for a number of years, but it had never been approved for this particular business. So in 2014, they were sent a letter of violation, notice of violation. They applied for a conditional use permit, which is what we requested them to do based on the use. They came to the board, and they were approved for a conditional use permit for their landscaping and snow removal business. At that time, I mean, there were a number of conditions added at that time. At that time, we didn't have a survey, but we thought we knew the boundaries of the property, and it was pretty clear in their application what they were applying for. So the uses they were applying for, you know, the buildings they were using, parking and so forth. So they were approved for a conditional use permit. One condition is they submitted a development plan to be approved by staff. We did that, so we approved the development plan. They moved forward, they moved on. We got a complaint, we started to get complaints, I think in 2019, that they were doing construction on the property. We went out and looked at it. They had bought 2 dilapidated buildings that were in front of their business, torn them down and started graveling the parking lot. So we sent them a letter, said you're expanding the use that's approved on the property. You need to come in and get an expanded conditional use permit. They did that. They complied. They filed the application. They came to the board in 2020. That's right. Yeah, 2020. You reviewed that application, I think it was in September 2020. It was initially maybe reviewed in August. There was a question about the property boundaries, so we postponed it for them to get a survey. So they completed a survey. So we had the exact property boundaries, and they came back before the board for approval for the expanded parking lot. I actually did the staff report on that, and we had gotten some complaints from Mr. Plunkett about the noise in the back of the property and the use of the back of the property. I actually put in the conditional use permit staff report recommendations for screening in the back. And my interpretation at the time was that, okay, they're coming back for an expanded conditional use permit. They expanded the parking lot in the front. Let's take care of any issues in the back, because that wasn't clear earlier in 14, you know, what that back part was approved for. Let's get the board to review that as well. So I put that kind of conditions to address that in the staff report. Well, I didn't attend that hearing, and after the fact, Charlie and Matt, who attended that hearing, it was on Zoom, so it was during the whole COVID. Well, we're still in COVID, I guess, but it was brought up that it wasn't advertised to address that the letter I sent out actually only specifically pointed out the parking lot in the front. So that new application in the notices, it didn't clearly state that the back part was being requested as well. So Charlie advised you and Matt advised you that you can't do anything on that back now, that, you know, you're only looking at the front parking lot. So you all approved the conditional use, the amended conditional use with the property and that front parking lot. That back parking lot was not really addressed. You said you can't look at that now, that it would have to be, you know, brought up either through a letter of violation from our office saying, no, that's not illegal, or a determination by me that that was part of the original approval and it's part of the business. There was a little bit of a miscommunication between Matt and I about whether, you know, that you all didn't even look at that. I thought you did look at that part. So anyway, when I went back and looked at the tape, I realized you all didn't even touch that. You didn't address it at all. So based on the complaints that we were getting, I went out to the property. Anyway, we can answer, we can answer questions if you have any at the end. I'm just trying to summarize it, mainly for Rachel, who wasn't on board. But so anyway, I sent out a letter of violation, and basically made the determination that that parking lot was not approved with the original 2014 approval. And how I based my finding was just looking at aerial photos, for one. So I looked at aerial photos starting back in 2000, and I have them on the PowerPoint, 2010, 2014, and current photos. And it was clear that that back part was improved for parking after the 2014 approval. So it wasn't, before that, it wasn't being used for parking, it was material storage. And their 2014 application actually stated, had a hand drawing and stated that that back part was material storage. So I made the determination that that was approved just for material storage. It wasn't approved as a parking lot. So that's what my letter is based on. This first part of the application is the property owner appealing that determination. So that's all this first part is. If you agree with my letter that that back parking lot was not part of the original approval, then that's all the action we need to take, I think, on that at this point. They would need to apply for an amended conditional use again to come back to get that back part approved for their current use of it as a parking lot. Otherwise, I think it's only approved for material storage. If you don't agree with my letter and you agree with the applicant's position, then based on what his position is, I mean, I think he's saying that that was part of the original approval. So then we would just make the determination that that back parking lot was approved already, and then we'd leave it at that. At least that's my understanding of the two options. Either, you know, reaffirm my letter in my position, or you know, take the position that that was already approved. And although it's not tied to it, there's a second application tonight for expanded parking in the front north side of the property, and that will come after this, after you make this initial determination.
Thank you.
Okay.
Okay, I have a question. I thought the July one was on Zoom, which we did not touch on this area, but I swear, when we talked about this area with the screening, we were in this room. Do y'all not remember it that way?
I can't remember whether we were or not, to be honest with you.
The meeting Joe's talking about, no, that was a Zoom meeting.
But there were two in 2020. There was a July and there was a September.
Yeah, either that or in August and September, I don't remember
Okay.
which.
But in
we-
September, wasn't Mr. Plunkett here in this room with us? No?
I don't,
Yes?
I think,
No?
I think they were.
It could have been in place in September. I watched
Yeah,
the video,
Yeah,
but
so we were in
the
here.
original
Okay.
one was Zoom.
Was Zoom, the first one was.
Yes.
Yeah.
But we did address this and that one because I was involved in some of the recommendations on the motion, and I made the motion, so I was just
I-
trying to make sure I was remembering correctly.
Yeah, I think you were in the room, but I believe that you talked about it and you decided that that was not, that area you weren't approving that back area. You were
Yeah.
just looking at the front parking
Yeah,
lot.
the specific recommendation was, and your all's action was, or maybe your action didn't even touch on it, but the consensus was, no, that was not part of this meeting's agenda, we can't deal with that. And we did not deal with that. That's why we then had subsequent discussions for a while as to just, you know, where it all goes next. But no, there was no action taken on that back lot.
Well, we don't have a full printout of the recommendations. Wasn't one of the recommendations from that night that we did go ahead and set in place a screening on the back, which I thought was, I mean, I referred to that in my motion, I'm pretty sure, and called that the backyard that we required the screening. That they went ahead.
That's the way I remember.
Yes.
Okay.
So that's my concern
We
is.
have the file and the conditions here. I can pull
Okay,
them out.
yeah, because I mean, it says that, but that was my concern, is I believe I made that motion with that condition on there. And although we had said it wasn't addressing that, we did put that in.
And all I can say is, I don't recall us taking action on it because we were really quite clear, we can't do that.
Right.
Because that's not what the public notice for that meeting contained. But even if you did take action on it, it can't be appropriate action because it was not part of the notice for the meeting. So it would not be a lawful action to take. So I really, there was some discussion because you all didn't really want to just let that slide and not deal with it, but we could not legally deal with it. And we argued about it a little bit, and that's the way it ended. So even if it somehow ended up in the motion, it would not be of any effect because that was not properly on the table in front of us that day.
I believe the last meeting that addressed this was back in the 2014 section, correct, where it was the rear yard. And Joe, you made reference a minute ago to a PowerPoint showing some of those. Do you have that?
But we
Yeah,
never saw
yeah,
that.
I can. Okay. I can't use the pointer, but we all know where we're talking about, where those three vehicles are in the back. Okay, this is the application from 2014 that the applicant submitted, and it notes that back part's on the right-hand side of the slide. It notes on it material storage, employee parking on the left side, equipment storage in the front.
Did we ever say this? I don't think so.
This is just from their application, shows kind of the amount of number of employees and the activity that they'd have in the business. And this is actually the staff-approved development plan after the meeting. And you can see on the right-hand side is that back area. It just designates it as yard and has some additional screening on the north side because during the meeting, we were just concerned with the farm, the owner who lived on the farm to the north. I don't think Mr. Plunkett was at the meeting. If he was, we didn't address that south side because the railroad was there and it was pretty, there's a tree line, along the railroad, but there was a berm and a buffer all along the north side added, you can see there, but the back part was designated yard on the approved development plan. I'm in trouble advancing here. Okay, these are the aerials. So this is from 2010. There were this is from Google Earth, so there weren't aerials every year, but this is the closest to the application. So in 2010, I remember 2010, it was kind of overgrown back there. I think they were using it somewhat to put materials back there, but there was no gravel parking lot at the time. And then it was, the business was approved for the 2014 amended conditional use. And then this image is from September, so right around that time, sometime between, probably, the applicant probably say when he did this, but sometime around the application, right after the application, I would guess, they gravelled it and put in this parking area, and you can see employees were parking back there at the time. I think now they're just using it for the mowing equipment and the trucks that pull the trailers. And this is current image, the most current image we have. And then this is just the zoning on the property, which we may get into. I just threw that in there.
Joe, could you go back to the September 14 image right quick?
What?
He wouldn't have done this if we hadn't had that in our minutes.
Okay, now back to the
2020,
2020, please. Okay.
So we talked.
I'm glad you printed it off.
Joe, do you have a copy of the staff recommendations from 2014 by any chance?
Yeah, I just have one copy.
Can we just see it, Mr. Oakley?
That was, that's why they my fault.
I mean, it's right here.
I know, because I said, I've already met the assistants.
Or they're on the last page, so they're perfect right here. Start there.
Just a 2014.
Yeah.
I think we had that too, yeah.
Bear with us as we read the Bible from back to 2014.
I've got the minutes from 2014, but I don't have the staff. I've got the minutes from 2014.
I got the staff report now.
I want to see what the conditions were.
Hang on, some of those.
It just refers to the conditions, but we don't have the conditions. Screens in the road. Is it in the yard in there?
Yeah, right.
What does it say?
Read number 2.
Yeah, number 2. But see, I can see as, well, I made that recommendation in 2010, we defined that as the yard, and that's what they've done to put their money into.
Did you read? Did I turn into this?
What was the other way? No, that's what they always said, push on it. Oh, well, Janet told me wrong then.
It doesn't make sense, does it? I mean, for me, it was like, the first thing was a big,
Yeah.
it says
That's the conditions from 2014.
2014, huh?
That's what they keep referring back to, it's the finished yard. So, if they did the 30th, I can't back down on what I intended, and they moved on. I already have established that, I'm not doing it again. But it's just legit.
I know. A couple guys in there. What he's gonna do is appeal it based on the fact that it's non-binding.
He's trying to.
He's gonna throw it out.
But I'm just saying, I have to go by what I intended and stick with it.
He's done all this.
Well, my thing was done, everything that was,
Do you want to read this? Yeah, what are they discussing?
Oh, that's the one I brought, yeah. Well, that's the 2014 we never saw before, but it does, it in there, it does. See, that's the one, look at number 2 on the conditions.
Things are offensive to me, but I just live with them.
That's within the and then we did that. To me.
that's the problem, right there.
That we can find. Hopefully he's still gonna, we'll see. See. Darren said that makes it actual, period. He said opposite.
I think there's a
That
difference.
did, because they can always hear us when you're just sitting. That's
I have
the
the
difference.
difference between parking
It's
lots
simple, push it in, that's when they can hear.
and parking.
They always hear us. You just put it
Yeah.
So, would it do?
No, because there's,
He had been. Well, that's my thing.
so I think we let him do this
Yeah,
one.
I'd say after you're done answering
That
the
I'm
question,
still
whether, yeah, turn over to the appellant and so
Say
on.
what I said before, like he's trying to say, I want to say no joke.
So we gotta hear.
You have to listen to theirs. Right? Of the letter.
Yes, ma'am.
Okay. They're looking at the 2014, but see, to me, the 2014 is relevant because we never had that. I said, other than the fact that the first of the
yeah,
year and everything else there, we never saw it. It was an influence in my decision
Started
in
to bring my
2020, so I hate to
computer,
go
but
back to it now. I mean, it's
That's
his decision,
truly
not our
on
decision.
Wi-Fi, so I wasn't sure I'd be able to get it. But yeah, all that's, I think, is part of the record in a couple of different places.
Right.
We have a copy of the minutes from,
Exactly.
you are
And
asking
then
about the
we did too, when we
2014,
said it.
Yes,
yeah, the 2014 minutes.
I have them.
Yeah.
Okay, that's,
Okay.
Yeah, they're in there.
So that's what I'm saying.
I mean-
think we have to go.
I don't have the
Just
copy of the
one
minutes
copy.
per se. I have the staff.
I have
report.
the minutes here. I have the minutes.
Yeah, the minutes were behind it, yeah.
I was about to say, here's the minutes he printed out a couple months ago. 2014 minutes.
Let us discuss, okay? And then we'll, because we also need to hear from
Yeah,
the applicant.
I didn't know if you had any other questions for me.
Not at the moment.
Okay.
I want to hear
We're
what the
trying to-
applicants have to say.
We're trying to figure out what, the chicken or the egg?
But based on their letter, they're going by
I just don't.
that motion. No. Like I said, what Greta is supposed to do.
So how many acres are we to now? We started at 3.5.
Yeah, we did. It states in there. The screening, I brought it up, Charlie.
It doesn't say, does it?
but 3 on the application we're on now, I got 3.8, but
But let's
So
see,
he didn't purchase that much.
3.8.
So now
it was
it's closed, it's like, get like a lawsuits and I know we got like 2 packets this big.
Am I being?
I don't need it. I'm still not wavered from what I said.
So Darren's got the minutes.
Can we see the minutes?
I
Are
don't.
you
Oh,
all?
you don't have,
I have the minutes. Here's the minutes. That's what you were looking at. That's the minutes.
no, this is the staff report.
No, you just handed that back to me. That's the minutes.
sorry.
Yeah, you looked at it. That's the minutes. That was the ones we had printed out in October, I think? Yeah. Or September.
Here's everything. Do you guys need this?
This is Joe's. Are y'all done with this
Yeah,
one?
Joe, there's your copy.
And that one you're looking at is my copy.
And then he gave us this one. Do you want your other one back? Or where did it?
I think nothing's changed from what I said before.
Well, and it went from.
Mm-hmm.
They're looking, purchased a big waterfront.
Mm-hmm. Okay.
Do you all have any other questions?
Now we
from-
ready to, I'm ready to hear
From them?
everything.
Then will you speak to us, please, the applicant?
Thank you. Joshua Harp, counsel for the applicant. Good evening, members of the board. As Mr. Kane has indicated, this first item on tonight's agenda is an appeal from his determination as set forth in his June letter, which opined that the rear yard, as you've seen on the development plan, was not to be used for parking as it is presently used and as the slides demonstrate, as it has been used since shortly after that development plan was approved in 2014. In fact, as has already been presented by Mr. Kane, that 2014 conditional use permit was approved. It contained an express condition that the application, or the applicant rather, shall park all vehicles and equipment inside the fenced yard. The only portion of the development plan that was in front of the Board of Adjustment at that time, the only part of that development plan that was labeled yard was in fact this back lot, this backyard that we're talking about. So there are essentially two bases for our appeal. One is that we believe that the use has been consistent with the development plan and with the conditional use permit as granted, insofar as that conditional use permit instructed the applicant, AFIX, to park in the rear yard, which is exactly what they did, what they promptly did not long after that conditional use permit and development plan were approved. I believe that the 2014 slide was from September of that year and demonstrates, if you wouldn't mind going back to that, as you can see, demonstrates that in September of 2014, that backyard was already being used for parking, and in this particular photo, there appeared to be 16 vehicles parked back there. In other words, this is not a one-off thing. This has been used for parking significantly back in 2014 up until now. It is significant as well that there were no complaints, as Mr. Kane indicated, until 2019. So 5 full years passed from the granting of the CUP, from the approval of the development plan, and from the beginning of the use of the lot for parking until there were complaints from Mr. Plunkett. It is incidental, and we believe not coincidental, that those complaints began from Mr. Plunkett at about the time that a different business dealing between Mr. Plunkett and Mr. Sweeney ended in a way that was less than wonderful for everyone. So there was some conflict surrounding that other unrelated issue, and that is when Mr. Plunkett began to complain about parking that had been taking place on this very lot for 5 years prior to those complaints. We believe that it's unreasonable for the Board of Adjustment to now interpret the conditional use permit as not allowing parking in the yard, when in fact the yard that is in question is the only thing that is labeled yard on the development plan that was approved, and it was based upon that the applicant began using that lot for parking at that time. Based upon the very letter of the conditional use permit, looking at the terms of the conditional use permit itself, looking at the development plan itself, there's, we believe, no question that in fact the use is compliant with and consistent with the conditional use that was granted back in 2014. Even if the board sees that differently, we believe that there is another fundamental reason that would make interpreting AFIX as being not in compliance with the conditional use permit inequitable. And that is because of the very reasons that were mentioned already briefly here tonight. This issue was contemplated by this board last year, and while it is correct that there was discussion about the propriety of considering the parking in the back lot, the backyard, when the only thing that was properly in front of the Board of Adjustment was the granting of the amended conditional use permit for the development of the parking areas in the purchased, acquired, and destroyed dilapidated housing near the front of the property. So at that time, that was the only thing that was actually in front of the Board of Adjustment, was the conditional use permit as applied to newly acquired property. Not even specifically to this lot, except insofar as it is now under common ownership and under common use. So we objected to the complaints about the parking on the back lot, and I believe a review of that video would demonstrate that when the board limited its inquiry to whether Mr. Plunkett had concerns about the parking and the use on the front lot, at that point he indicated that he had no concerns or objections to the use of the front, the new lot, and at that point the board granted the conditional use permit, the amended conditional use permit, and allowed the parking lot that had at that point been constructed, allowed that to be approved, subject to several conditions. One of those conditions was, notwithstanding the discussion about whether it was appropriate to consider the objections about the parking in the back lot, notwithstanding the fact that the board determined, I believe properly, that that was not properly in front of the board, one of the conditions imposed upon AFIX was in fact to screen that back lot, was to include screening back there precisely to address the concerns that Mr. Plunkett had raised at that meeting. Mr. Sweeney is here, and he'll be prepared to testify just how much money they spent doing exactly that. They have installed additional screening, not only artificial screening, but also installed trees. It looks great. So relying upon this board's conditional use permit as amended and relying upon the instruction to screen the back of that lot to pacify or to appease or to satisfy, whatever word you like to use, to address the concerns raised by Mr. Plunkett, AFIX did in fact spend a significant amount of money doing exactly that. We believe that it is inequitable to now come back a year later and say that AFIX can no longer use that back lot for the very thing that it has been doing since 2014, based upon the fact that an interpretation of what the word yard means seems to imply, or at very least, a fair reading allows for the parking to take place and for that back lot to be used for parking, but also based upon the equity of this board knowing that that yard was used for parking, knowing that Mr. Plunkett objected to the parking and what he believes are the sounds that he objects to, the sounds of the business ongoing, which is my understanding as to what he primarily objects to, the noises that go with operating a business. Obviously, I don't want to speak for him. He'll be, I'm sure, happy to speak for himself. But based upon those concerns that were raised by him, this board imposed upon my client, AFIX, the obligation to spend money to address those concerns, which it faithfully and promptly did. We believe that it is wildly inequitable to now, a year later, come back and say, never mind, even after attempting to comply with the board's obligations and doing so, and even after addressing the concerns relative to parking, we're not going to allow you to use that back lot for parking. So for those reasons, we believe respectfully that Mr. Kane's interpretation of the conditional use permit as granted, and in light of the development plan that was approved, we believe that he's mistaken, respectfully, as to whether there is in fact a violation. At the risk of seeming that I am throwing Mr. Kane under the bus, it's not what I intend to do. However, I do think that it is important. It is relevant that through an open records request where we were seeking some records pertaining to discussions and communications about this address, we were provided through Mr. Kane's office a September 22nd, 2020 email from Mr. Kane to Mr. Perkins. This is September of 2020. There's no doubt that in September of 2020, there's no questions about whether the lot is being used for parking. There's no ambiguities about how the yard is being used. There are no issues. Mr. Kane says at that point, I don't believe there is a violation. He says at the 2014 approval, nothing was ever brought up about the property on the other side of the railroad or screening from it. Then skipping down, he says, I don't believe we have a basis for issuing a notice of violation. While I realize that he may have been sending this email based upon somewhat limited information, and again, I don't wish to minimize what he may have done and learned in the meanwhile, the fact is that in September of 2020, Mr. Kane knows how the property is being used, and it is his opinion at that time that there is no violation. It is at about that time that Mr. Plunkett raises his concerns about the parking in the back lot. It is at about that time that this board directs AFIX to construct additional screening and plant trees and do things to mitigate or address Mr. Plunkett's concerns, and it is about that time or shortly thereafter that AFIX in fact does that. It was until this year that then APEX receives a letter from Mr. Kane indicating that now we have a problem, now it's not consistent with the conditional use permit. So respectfully, we cry foul on the basis that, number one, the use is consistent with the CUP and the terms of the CUP as granted, and number two, it is extraordinarily inequitable to direct APEX to construct the screening and then move the goalposts. Finally, we also believe respectfully that Mr. Plunkett's objections or concerns, we frankly believe that they are somewhat overstated. Again, Mr. Sweeney will be able to testify briefly to the fact that there is some extraneous conflict that occurred at about the time that Mr. Plunkett determined that he had objections and started raising those objections. And also, to overstate or to state the obvious, there is a train in between Mr. Sweeney's property, the APEX operation, and Mr. Plunkett. It is extraordinary to me that Mr. Plunkett may be used to and accustomed to an active rail line and all of the noise that that creates, including whistles that are blown every single time a train crosses that road in front of his house, and yet be disturbed by the sounds that come from maybe backing up or loading a few trucks in the beginning of the day or at the evening. So we believe that his concerns are disingenuous. We believe that they are overstated based upon other conflict between him and Mr. Sweeney that simply is not relevant. I'll be happy to answer any questions that I can before then taking some testimony from Mr. Sweeney.
Do you have any questions? Mr. Sweeney?
Thank you.
Say your name, please.
Alan Sweeney,
Can you state your title with APEX?
President Owner.
And as president and owner of APEX, are you familiar with the operations of the business and the property at 390 Paynes Depot Road?
Yes, sir.
What is the business that is there?
Commercial grounds maintenance.
Now, we've been talking about the backyard. We all know what we're talking about there. That's the portion on the screen there that is on the southeast corner of the property where those cars are parked in the photo.
Yes, sir, that is correct.
Please inform the board how that yard is currently used.
It's currently used for parking of our trucks and trailers and some equipment, some material throughout the day.
And approximately how many trucks do you typically park there on a given day?
Typically, I think there's 7 or 8 parking spots if we go to the, so there we are. How many is there? 1, 2, 3, 4, about 7. So those are basically, they're mowing rigs that park there in the evenings and they leave in the morning. So guys, they're back there for about 5 minutes in the morning to grab the truck, pull it to the front, and then when they come back in the afternoon, that's where they park.
And this image that we have here from February 21, 2020, that shows several trucks parked back there at the far southeast corner of the lot, is this consistent with end-of-day parking typically?
It is, yes, sir.
Is there typically significantly more parking that is happening on this lot at any given time?
This is typical end of day. You could get maybe a couple more in front of the truck closer to the farm, farthest away from the railroad track. Maybe 1 or 2 would park there because of space, but that is how we park.
And I can observe that in this photo, the trucks and their trailers appear to be backed into those spaces. Is that too consistent with how this lot is typically used?
Yes, sir.
In the mornings, when trucks leave, when staff comes in and they take the trucks out, approximately what time do your employees come to the backyard and leave with the vehicles?
Between 6:45 and 7 a.m.
And between 6:45 and 7 a.m., what do they do with the vehicles?
So typically, it's a foreman for us. Our employees park in the area that was improved last year, so most of our production crew, they stay in that area. Our supervisors get the keys from the office, get the trucks, and pull forward. There may be 1 or 2 that could go back and help them if they need something, get in the truck, but typically our supervisor grabs the truck, pulls it actually to the front gate where they pick up their entire crew, and then they leave for the day.
So I take it from what you've just described that however many vehicles are parked at the backyard at the end of the day is approximately how many employees will be in that lot the next morning.
Typically, yes, sir.
Okay, and again, I see that these vehicles are backed into those spaces. Is there typically anything in the mornings that requires any employees to back up vehicles?
Not typically, only if You can see a few trailers on the railroad side below the mulch bin. Maybe a crew has to grab a trailer that morning if they're doing something different, so that would be the only reversing to pick up something in the mornings.
And what about in the evenings when vehicles return to this lot? Approximately what time, are the vehicles backed into the back lot?
So our standard office hours, we try to quit at 6 p.m. Now, we do have crews in the spring, it's busy for us, and grass grows and it rains, and so we have days that are late in the evening that, you know, it's not every crew, but you're gonna have a few crews that come in towards dark, towards the end of the day.
Now, not to take things too much out of order, but I do believe this is relevant. We also have an amended CUP application also on the agenda tonight for additional parking at the north end of the property, correct?
Yes, sir.
Can you describe for the board how you expect the use, if approved, of that northern lot will impact the use of the backyard?
So we've been blessed. As you can see, there's a lot of vehicles in that space. And so our desire is to take, it's in dirt there now, but behind the parking area and behind those two buildings, we would create access getting in. And so, as I mentioned, sometimes there's a couple more trucks parked along the horse farm fence on the lower side, and then there's trailers on the other side. So it would allow us to move some vehicles, and we've been growing, so we are acquiring more vehicles, more trucks, more trailers. And so essentially, we need space to park those and turn them around safely. It gets, safety is a big concern for our company, so as the lot gets tighter, then that becomes a concern and an issue. And so by having an option to expand into that, what is the dirt in the picture grass area now, it would move some trucks and trailers, but it's for the continued growth and to alleviate some, but there would still be those trucks along the backside and trailers similar to what it is, but some of the stuff even pushing out along the horse farm side would be able to move down into that lower spot.
If approved, the conditional use for the northern lot, would that reduce or increase or have no effect on the parking in the back lot?
It would reduce the amount of parking back there because we take the stuff that we're overflowing into it and push it down.
Believe it's true, and we had a 2014 photo that indicates that you began to improve that property, the back lot, in 2014. Is that correct?
Yes, sir.
And if the board doesn't mind, we do have some booklets that are prepared for the board. If I may approach and hand those out.
I'm having flashback to landfill.
Thanks.
First day I came in, made notebooks.
Thank you.
Thank you.
And, yes.
Yeah, we've already seen all that coming in.
Mr. Sweeney, if you could, can you just walk through this booklet that's been provided to the board and explain to the board what these photos depict, please?
Absolutely. So I'll try to move rather quickly for you. It's a lot of photos. So if you open up, the first few photos just take you back to prior to us purchasing the houses out front. I think we all reviewed some of these before. A lot of you are familiar with the area, so what it looked like. So these were photos we actually took as we were trying to purchase and getting some. And you can see the trash, actually some of the drug paraphernalia and everything that was in the lot, in the yard, out front. It was unsafe for our office employees and everything there. So if you move fairly quickly through them, you'll get to a picture that is, I believe, the actual screening. Yep, so there's a picture of an excavator tearing down the house, and then the next picture is the fence and the screening that was requested during the 2020 approval CUP of the front lot. So we did put that up. You can kind of see behind them, there's a pine screening. So there's the fence with the barrier, and then the trees following that. And then as you just go for the next pictures, it's basically just showing, there were some conditions in the 2020, so there was some screening along Mr. Richardson's property, there was landscaping as the plan had described, so we put in the landscaping, the sign, and then fencing. You can see we cleaned up, sodded parts of the front. There was a request for concreting the entrance. We did that. We worked with Kentucky Department of Highways to get they wanted us to you all had asked that we designate an entrance so that for safety off the railroad track, so we put all that in. So these pictures are just kind of showing you the transition of the property since 2014, and essentially since 2020, there's been quite a bit done. And so as you move through pretty quickly through those, the very last page is actually the expenses we incurred, and it's not, I'm sorry, it's the paper sheet in the very back. That is the expenses we incurred for the conditions that were in the CUP. So this has nothing to do with purchasing, demolishing, building the parking lot. This is just the expenses based on the CUP request. So the request was the concrete installation there, so we had to do it pretty thick. There's over 50 yards in that front piece. That was the labor for it. The fencing that was on the site plan, the sod, seed, site prep, excavation for that entrance. The screening in the back is that Howard fencing, the green screen that they put on it, the trees in the screen, that was the invoices for that. Fuel tanks, if I bring your attention there, that's probably a shocker. So you all had requested that we get tanks that were adequate to fire marshal, and so what we had for years, but we brought in the Scott County Fire Marshal, and then that went to like a state directive and all stuff. So we have some tanks that I would venture to say, but not be able to confirm, are probably state of the art and above what you could probably find in most places here. So they're non-combustible, they're fire rated, they're a high dollar tank, as you can see. So that's what we had to get to meet the fire marshal's requirement. Then you look at the electrical piece, we had to put in emergency shutoffs, we had to put in underground wiring, we had to put in fire resistant coating, it was a pretty extensive process. So we actually got not shut down, we were asked to stop using the tanks in February because to be compliant with the CUP, we had to move them out from where we were and then start hand cranking. Our guys had to put hand cranks on and hand crank fuel. So from February to July till we could get basically our fuel station built, we estimated it to be about 550 man hours of guys just sitting there cranking fuel every morning. And so it comes down to about 119,000, and that was just to satisfy the CUP for 2020. So we just wanted to present that for your review. Thank you.
And to clarify, so make sure that the board understands that these costs, you referred a couple times to the CUP, these costs of approximately $119,000 are in order to comply with the conditions of the board as granted in the conditional use, the amended CUP in 2020.
That's correct, yes, sir.
So these are not costs that were incurred back in 2014, between 2014 and 2020.
No, sir.
These are to comply with this board's last order relative to the property.
That's correct.
Do you know Mr. Plunkett?
Yes, sir.
How do you know Mr. Plunkett?
He is our neighbor in the back corner across the railroad tracks.
Can you identify where his house is on the photo that's on the screen?
It'd be the bottom right, kind of metal roof there, just along the edge of the tracks. Part of it's cut, his shop is cut off of the picture.
That's the building, the structure that is closest to the bottom of the screen, correct?
Yes, sir.
Have you had some business dealings with Mr. Plunkett?
Yes, sir.
Can you tell the board very briefly what they were?
I'm objecting to this line of questioning. This has nothing to do with the appeal of the Scott County zoning officer's decision. To get into the motivation of the complaining party is irrelevant to your all's decision. Suffice it to say, he filed a complaint, but the decision that you all have to make tonight, the issue that you have to decide is, did Mr. Kane correctly interpret the situation or not? What kind of relationship Mr. Sweeney and my client had is totally irrelevant to those proceedings. They want to load up on and make Mr. Paget look like a bad guy. I'm going to have to make Mr. Sweeney look like a bad guy. That's collateral of just rumor and innuendo that is really a disservice to this body, is not relevant, and I object to any questions, further questions about this matter.
Well, I'm not a judge, so I can't grant you your objection or not.
If you're the chair, yes, ma'am, you can. If you consider that irrelevant, you can make a ruling, and if the rest of the board disagrees, they can motion second and overrule that. But, oh, absolutely, that's, you're the one.
Can we give her our input to help her?
Well, you can discuss it, certainly.
I don't think.
And respectfully, you also get to hear my response to the objection.
By all means.
Our response to the objection is that we, again, do not believe that the concerns about the property are, I won't go so far as to say they're not legitimate. We believe that they are overstated, and we believe that the objections Mr. Plunkett has raised have been overstated and exaggerated. Nevertheless, Mr. Sweeney has complied with the directives of this board to address those concerns, even though they are overblown, which goes directly to the equity and the appropriateness of now pulling the rug out from underneath my client. Because if they were not legitimate and wholesome complaints and concerns in the first place, then it goes all the further to demonstrate that my client has gone above and beyond to address concerns, and now the board is contemplating shifting the goalposts. So we believe that the testimony is relevant. We do not wish to get into the very specific details of the transaction, but we do believe it would be helpful and relevant for the board to understand that there were some dealings and that they went sideways.
I think we now know there's bad blood. We know there's bad blood.
Again, it's not about Mr. Kane or Mr. Patch's complaint. That's not what the appeal is from. They didn't appeal what Mr. Patch's complaints. They appealed Mr. Kane's decision. That's what we all have to decide. And we get in back and forth, and I got to put Mr. Patchett up here, and we get into all this drama about whatever kind of falling out they had. It is totally irrelevant to your decision about Mr. Kane.
Thank you. Thank you both. Do you have anything else to say?
Yeah, with your permission, I would like to put a couple of those details on the record.
Go ahead.
Thank you. I believe the question, Mr. Sweeney, was, can you tell the board very briefly what were the dealings that you had with Mr. Plunkett?
Very briefly, I had a partnership with another guy out of Frankfurt that we were creating a patented product for the power sports industry. We started that process, brought Mr. Plunkett in because he's a very talented metal worker, framer, stuff like that. He's done a lot of work for our company prior to 2019. His timeline was a little slower than we desired, so we took some options but still wanted to work with him. That deal fell apart. To end the story, the patent, somebody beat us to the patent, so the whole thing fell apart for us. But at the moment that Mr. Plunkett realized we were working with some other engineers to speed the process, it became very hostile, and that ended.
And was there a disagreement initially about how much money was owed to Mr. Plunkett?
There was, yes, sir.
Was that ultimately resolved?
Yes, sir.
Do you remember approximately when that was resolved?
Several months after, in end of 2019, some fall of 2019, I believe, summer, fall.
And prior to, well, let me ask you this. Have you received complaints about your operations at Haynes Depot Road from anyone other than Mr. Plunkett in the past 2 years?
No, sir.
Thank you.
We just would simply point out that this is coincidental with what Mr. Kane said earlier, which was that in 2019 is when the complaint started.
Thank you.
Thank you.
Now, Darren, you would like to say something?
Not now.
Okay. So we appreciate you giving your input, and then we have to ask if there are complaints or hear from the other people involved.
Understand. Thank you.
Thank you. I know.
Wait a minute. Why is he relevant to Joe Kane's decision?
Thank you, Madam Chair, members of the board. I'm Bruce Simpson. I'm an attorney from Lexington, and I represent Mr. and Ms. Plunkett in connection with their opposition to this appeal. I'm not really going to get into the facts that much because the ultimate position from us is that you all are precluded from granting this appeal as well as the conditional use permit as a matter of law. I'll get into that just a little bit. But just in terms of some background facts to give you a sense, if you will, of where this case is factually, even though the facts that I'm about to share are really only responding to part of what counsel for Mr. Sweeney had to say. The fact that Mr. Sweeney has a complaint has nothing to do with Mr. Joe Kane's decision that in 2014, this board, and I don't know if any of you were on that board at that time, made a decision that did not include the rear portion of the property for parking lot. That's his decision. Now, counsel for Mr. Sweeney says, well, but Joe Kane in 2020, based on an email that I got through Open Records, said, I don't know if we can issue a violation or not. And then we move forward to 2021, after I point out Mr. Kane looked at the tape of meetings, studied it further, and concluded that in 2014, the applicant did not request, and the board did not approve, parking in the area that we're talking about tonight for the purposes of this appeal. So, is Joe to be faulted because he did further research and made a decision? I've been doing this a while. The staff is always put in the middle. When they're for you, you like it, and when not for you, they don't like it. But to cast aspersions on Mr. Kane's judgment or the process of his evaluation based upon his report, which is entirely factually supported in the record, that this application did not only request it, the board did not approve parking on in this area. I ask you to keep that in mind. Joe is the only impartial witness that you're going to hear tonight. And staff always has to be in the middle sometimes between competing sides, competing interests, when those arise, as they have tonight. And I've always found Joe, even when I disagree with him, I didn't dispute his reasoning. I disagree with his conclusion, but I didn't disagree with his judgment or his professionalism. I've never found that to be the case. I certainly don't tonight. So, where are we?
I'm not sure.
Well, I hope to clarify it for you.
Please.
I find it interesting that counsel for Mr. Sweeney keeps complaining about equity and the heavy burden that this board placed upon his client in 2020 by putting up screening and buffering and the like. And he showed some selected photographs of the screening that he installed. Most of that, it was on his side of the, internally to his property. But here's the deal on that. If those conditions were so onerous, as counsel for Mr. Sweeney proclaims repeatedly, if they were so onerous and so expensive, he should have taken appeal of the board's decision and saying, you know, you didn't have justification to impose those conditions. That's every lawyer's right to advise their client. The board shouldn't have done that. You shouldn't have had to spend $120,000. Well, there wasn't any appeal taken of that decision. They accepted it willingly, apparently. They could have challenged it, but they didn't. So how can they now complain that it's this great burden on them when they didn't challenge it when they had the opportunity to do so? Now, they showed photographs of some internal screening. I'm just going to show you one of what it looks like from Mr. Plunkett, Mr. and Ms. Plunkett's side. Pass those down, please, ma'am. Thank you. So this is the great screening that is supposed to mitigate the noise from the early morning trucks and the beep, beep, beep and the backing up and the snow removal of this increasingly large and successful business. And I compliment Mr. Sweeney on being a successful business. He's been very successful. Unfortunately, his success has been at the expense of the quality of life of Mr. and Ms. Plunkett. I submit to you that These skimpy little trees don't block anything. They don't screen anything. But this is the photograph that was taken today. Now, in terms of what I believe are the critical elements of this case and the application for the conditional use request that follows this appeal. And, well, I got one more thing, just to deal with the appeal.
You're asking an awful lot.
I'm sorry. What is being passed out to you, and really it underpins what has already been testified by Mr. Kane. He actually put up a slide reflecting this point that I'm about to make. But this is the application that was filed for Mr. Sweeney back in 2014, January 17th, 2014. So what was the application? What did it request? What illustrations went with it to depict what was really sought at that time? Was there a specific designation that this area back that we're talking about tonight was for parking? If you look at the very first exhibit of Mr. Skip Gaines' application, after he finishes his narrative, down at the bottom he's got in chronological order all of the exhibits that go with his application. And the very first exhibit is a development or a sketch plan of what he wants, and it's labeled the area that we're talking about. Material storage, exhibit number 1. Now, to me, that evidence is a clear intent that Mr. Sweeney, at the time of application through his lawyer, wanted this area to be used for material storage. It's clearly there. Now, counsel for Mr. Sweeney has then taken a development plan that was to be used for Planning Commission approval after the Board of Adjustment made the decision in which Tony Barrett, who put the plan together, designated this area as a yard. Well, the yard wasn't on the application. The application was before the board, and upon which this board made a decision, said material storage. That's what it said. There's no dispute about that. So that's what was before the board, and I submit that's what they decided, notwithstanding these oppressive conditions that this board placed upon Mr. Sweeney in 2020, for which they were accepted and no appeal was taken. Now, those are factual matters. The other factual matter that's really critical in this case is that as we appear before you tonight, the zoning of the property in question is A1. The upper part of the property for which he seeks a conditional use permit is zoned R1B, single-family residential. Those are the zones that are in place tonight. So with those zones in place, for which there's no dispute, what does the law say that an applicant can do with respect to seeking a conditional use permit, or even to expand upon the permit that he got in 2014? And if you grant this appeal, you will allow an expansion, a change of it. And so what I'm about to share with you in terms of our presentation goes hand in glove with our opposition to the request for a conditional use permit. We're all guided by the law. please understand, I'm not here to lecture anybody about the law. You have competent counsel. Charlie Perkins has served this board and the Planning Commission for many years. If I'm going out in the range of Neptune and Pluto on what I'm about to share, he will call me on it. I'm sure Mr. Harp will call me on it as well. But the law speaks for itself. And so all you have to do is read what the law says in terms of guiding you all in making decisions when there's controversy. And there's a controversy tonight, obviously. And so the statutes that govern planning and zoning in Kentucky are in KRS Chapter 100. That is the land use Bible, if you will, permit me to make that characterization, that guides planning and zoning decisions. That in matters of controversy, we don't rely upon equity. We don't rely upon whether we like the applicant or don't like the objectors. That's not relevant. What is relevant is the guidelines of the law that say this is what you have to do to get a conditional use permit for you all to make a decision. And KRS 100-237 simply says, the board, meaning the Board of Adjustment, shall have the power to hear and decide applications for conditional use permits to allow for the proper integration into the community of uses which are, critical word, uses which are specifically named in the zoning regulations, which may be suitable only in specific locations in the zone, only if certain conditions are met. The critical word there is to allow for proper integration in the community of uses which are specifically named in the zoning regulations. So what are the zoning regulations that govern A1 and R1B? Because that's the zone of Mr. Sweeney's property here tonight. If you look at the existing zones for R1B and A1, you will not find any mention, any reference whatsoever of a lawn care, snow removal, conditional use that's permitted as a conditional use under either of those zones. Now, that's what the law says. You have to have a specific use named in the zoning ordinance. And the lawn care, snow removal option is not present as a matter of law. The law speaks for itself for R1B or A1 zoning. So you can't expand it for the A1 because there's no use there that's available for that. Likewise, the conditional use in the R1B zone doesn't allow for it. So, and it's not a permitted use. Certainly not in a single-family zone where they seek to expand the parking. And it's not an agricultural use as defined by your zoning ordinance. So there's no provision in the law to allow them to get a conditional use permit. And you say, well, but they've already got a conditional use permit. Well, they have. And that was wrong. And no appeal was taken from that decision. I wasn't involved in either of those cases, dating going back to 2014. But the law also says the provisions of KRS 100-237, or any statute in KRS Chapter 100, have to be explicitly followed. It is a strict compliance standard under the law, court after court. And I'm just going to tell you this share this one case for the record. In the case of Nicholasville Road Neighborhood Consortium versus Lexington Fayette Urban County Government, there were two attorneys that agreed to postpone a case and waive the 90-day rule that's set up to allow the Planning Commission to make a recommendation, the legislative body to hear it. They agreed to waive it. And the Court of Appeals said you can't waive the statute. It's mandatory. It has to be followed. Strict compliance. So the fact that it's been granted previous conditional use permits doesn't apply tonight. Tonight, it should stop. If Mr. Sweeney wants to continue his operations, or I should say expand his operations any further, he needs to get a zone change. There is a remedy available. He can get a zone change for the appropriate zone that allows for his use, and that's what it's set up to do. But it's not through a conditional use permit for which is not expressly provided in your laws. These are your laws. These are Scott County laws. The other aspect of the law that comes into play here is that this property has been used for a number of years, obviously, zoned R1B, single family, and A1, in a manner for which no conditional use permit is authorized. There's no dispute about that. And there's also no dispute that it's a non-conforming use, meaning that the use that is being put on this property now, because it's not a conditional use in either A1 or R1B, it's not a conditional use in either of those zones, but it's been allowed to operate. That's a non-conforming use. Okay, so what about it, Simpson? What's the significance of a non-conforming use? Well, the law says, your law, Scott County law and state law, provides that you cannot expand a non-conforming use. You just can't do it. You can continue to operate as a non-conforming use within the same footprint of your operation that you got approved for, albeit wrongfully, but you can't expand it. And so tonight they seek an appeal to expand the use to parking. Tonight they seek a conditional use to expand this operation for additional use that's not allowed in the zone for which they're seeking a conditional use permit. So for those reasons, in terms of the law, that's what you have, with due respect, that's what you have to follow. And on that basis, we would ask that this body deny the appeal and deny the conditional use permit. I do have findings of fact to support the denial of the appeal, and for the denial of the conditional zoning request, I would simply say that if you crafted a finding that simply stated the subject property is zoned R1B and A1, neither of those zones allow for a conditional use of the type sought tonight, and property being a conditional, a non-conforming use, it can't be expanded, and for those reasons, the conditional use request must be denied. I'll pass these findings out to Mr. Perkins, just in the event that you all see fit to use them. But in my judgment, the law precludes approval or granting the appeal sought by Mr. Sweeney, and it precludes this body from approving the expanded conditional use permit. I'd be happy to respond to any questions.
And I can explain it like I want
What do you say?
Do you all have any questions, more questions?
No, probably plenty, but not right now.
Thank you.
Do we have anyone else who wants to speak in regard to this?
before you get that.
I think there are a couple more people who would like to speak. With the board's permission, the chair's permission, I'd like to address very briefly the legal arguments that Mr. Simpson has made. I'll do my very best not to belabor the point. As I understand Mr. Simpson's rather novel argument, that is that the 2014 conditional use permit should never have been granted. I believe that the board can talk to Mr. Kane. I was not at the 2014 meeting. I simply know what the conditional use permit and the approved development plan from those dates, what those reflect. But I am confident that Mr. Kane will testify that, in fact, whether a landscape business such as Afix's was appropriate in this area, in this zone as a conditional use, was in fact extensively considered by this board. I'll also point out that it is interesting that Mr. Simpson wants to claim strict compliance with the statute. It's my understanding that Mr. Plunkett has lived at that location since before 2014. He's been there all this time. What was not pointed out to you is that KRS 100.347 says, any person or entity claiming to be injured or aggrieved by any final action of the Board of Adjustment shall appeal from the action to the circuit court of the county in which the property, which is the subject of the action of the Board of Adjustment, lies. Such appeal shall be taken within 30 days, not 30 years. It is extraordinarily disingenuous for Mr. Plunkett to now take the position that the CUP should never have been granted back in 2014, and apparently want this board to revoke that, while also arguing that there's a strict compliance requirement relative to statutes of limitation. We believe that the CUP was appropriate as granted. There was also some discussion that he just gave about whether the zone should be changed. That is, in fact, a discussion that the board may recall was something that Mr. Kane asked for as a condition of the 2020 conditional use permit, was that if and when sought by the county, whether AFIX would cooperate with the rezoning of that property. And of course, we remain able and willing to do so because that was one of the conditions of the 2020 amendment. I also submit that I believe that the argument that we can simply have it rezoned to a zone that permits specifically land use like that's going to specifically mention landscaping or snow removal, I believe you'll find that that isn't in any zone in Scott County, and therefore it is not so simple as we'll just rezone it to a district that allows that, because you'll find that it's vacant, which is why this board considered that issue back in 2014 and granted the 2014 CUP nevertheless. Thank you.
Thank you. Mr. Plunkett, you wanted to speak?
Can the bad guy talk for a minute? So they're right. I've lived there since 1988. I started renting it. Bought it in 94. Can we get that picture from 2021 or whatever it was, the last one? That's my house. If you take and do Google Earth, from my front porch to that trailer, that first trailer, is 93 feet. I'm 1,500 feet almost from the road. If you look on this side, the top side, you'll see that's a horse farm. Nice place. On the other side of me is a cattle farm. Behind me, just vacant land. Been nice, peaceful, quiet. I've been there since 1988. All of a sudden, I've got a landscape guy that wants to come in 2014, and if you look at his application, he states 30 employees. It's in there. I'm going to guess we've got 100 plus employees. How many employees do you have?
If the board would like to ask questions directly, that'd be fine.
Okay,
but
I'm guessing 100 plus employees. Now, this lot back here that everybody says Mr. Plunkett and him fell out over a financial dealing, we had been having discussions since 2014. We had a hot tub on our front porch. We had guys coming and going all night long. We couldn't use the hot tub. We couldn't barbecue on the front porch anymore. We couldn't have any privacy, period. We moved the hot tub and stuff. I'd been having talks with Alan. I've always been told you don't sue your neighbors. I've never sued anybody. Tried to talk to him, tried to do this nicely. When the other thing went south, I said, look, this needs taken care of. It's a bunch of crap. So they're trying to twist this and make me look like the bad guy. But we had been talking about that since he had employees going back in there. Before dawn, the first slide showed that they were using it for employees. Well, these guys are coming in with their radios going. They're out there talking, doors banging before dawn. Then they're walking up front, getting in the trucks. So to try and help it, he puts the trucks in the back. That's all good and well. Have you ever heard an enclosed trailer on gravel banging out in the morning? It's not quiet. I had a video that I should have brought and played of some of the noise. Then, every night, they pull in. By law, they gotta have backup beepers on all this stuff. They're down there backing up, gravel spinning, whatever. Here's another thing that nobody's brought up. We've got a conditional use permit. In there it says no noises and no light flashes in the 2014 one. When we're doing snow removal, that's an all-night long process. That salt dome you see right there, we have trucks coming and going all night long, being loaded with salt. We have flashing lights, backup beepers, things banging and beating. That's about 150, 200 feet from my front porch, all night long. The reason I'm the bad guy, if you look, I'm the only house. I'm the only person it affects. Guy up there, he's 80 years old. He can barely hear. He wouldn't know. The store up front, they're gone at night. The people up front, they wouldn't know. They wouldn't hear it. It's all in my front yard. I'm not the bad guy. I'm the guy that's been there 30 years that's all of a sudden got a great big business that was supposed to be 30 people. He's been successful. Great, I'm glad for him. Now that he's successful, he needs to be in an I-1 location. He shouldn't even be there. He sure shouldn't be allowed to expand. And that parking area that he wants to put in now and go, oh, that'll alleviate some of his parking out back. That's what I heard on the last parking thing, that they were going to alleviate my problems out back. That's why I didn't object to the parking area out front. And if you go back and watch the tape, you'll see that. He says that. That's all I've got.
Thank you. Do we have anybody else?
Robert Richardson, and I live in the house on the front on 420, directly next to the new parking lot. So, with like Greg's saying, nobody else is affected. Every truck or trailer that pulls into Al's parking lot goes directly by my house, within 25 feet of my house. I can't tell you when the last truck pulled in. I can't tell you when the last truck pulled out, because I don't hear it. I don't hear it. I don't see the flashing lights. I don't. That parking area, the landscaping that Mr. Sweeney's done has been great. It doesn't affect me, but like I said, if there's 7 trailers back there, and if there's 30 employees, 50 employees, 100, that means every single one of them go by my house every day. And like I said, I can't tell you the last time, I can't tell you when Al's truck left this morning. I can't tell you when the last one come home last night. I have no idea. I don't hear it. And like I said, from my house, there's 5 foot from my driveway's 16 foot, and then I'm 12 foot to the parking lot. I'm less than 50 foot away, and I can't, and on the snow plowing nights, if they're flashing lights back there, they're flashing them by my house. I couldn't tell you. My bedroom is directly facing that parking lot. I don't know. I don't hear, I don't, and I hear pretty good. You know, I don't hear nothing. I'm happy with what was done out there. I'm thankful for what was done. I think everybody can see that corners come out tremendous to what it used to be, and I really hope you guys take that into consideration.
Thank you.
I'd like to add one thing to Mr. Richardson's. The houses up front that they tore down, they do look good. All that looks great up front. But as part of that process, there was a land swap done between these two right here, so this guy could have his sewer to get his house going. They didn't put that in when they just talked.
This will be the last.
Okay, I just want to clarify that.
Thank you.
I want to clarify that. He's right. There was a land swap between myself and Alan Sweeney. That land swap was done to make the lots more compliant. And I think you guys remember when we come in. By the land swap was to add more property to Alan, to bring him more compliance. So we weren't on such an undersized lot, but that has no bearing on what was said about the noise of the landscape company.
Thank you. Charlie, we need some advice in reference to the KRS.
Well, how about I go home and have supper first, and maybe y'all will figure it out. If you really need me, I can come back some other time. The problem with this thing is that it began as, well, let me back up even further. It began in probably too free and not interpretation, just a too free and a following of the applicable law. By that I mean, there had been an industrial type use there off and on for years. I don't even know that I could remember when there wasn't something like that there. And as such, the board did not want, and it's not only in this particular property, it's in other properties, didn't want to say to somebody, sorry, but that was a non-conforming use, you're going to stop it now, and basically you lose all the value, and you got all this cleanup to do if you're going to ever have anything. The statute says we should be doing that, and we've just not done that maybe ever. So when this first came in, maybe even an application before this one, I'm not sure. I think we've had maybe one or two even before this one. And they were non-conforming use considerations. They weren't conditional uses. I frankly don't recall why this was considered a conditional use. I was thinking this was also a non-conforming use determination, but I see Mr. Gaines characterize it as a conditional use. The fact is, the law is a conditional use needs to be specifically named in the zone where it is, where it's being requested. This was really a non-conforming use. They had industrial use. This was going to be a semi-comparable use to maintain property values and whatnot. It was approved. And again, this one is not the first one. I think this has been done even before. So that explains why Mr. Simpson talked about it should not have been approved in the first place as a conditional use. No, it really shouldn't have. But maybe Skip Gaines introduced it, and I can tell you right now, Skip's one of the best attorneys I've ever worked with, so I'm sure he had a reason for that, and I'm probably mistaken about something there, but generally speaking, no, a conditional use has to be listed. That's why you have those little finite lists of what a conditional use is approved in each zone. Now, as far as the R1B, I was really hoping this one didn't include that, and I didn't look close enough. I was hoping this was just more of the A1 historic errors that we've made on this. If it's R1B, well, of course, there's no such thing as a conditional use landscaping in a residential zone. But I can,
There's the zoning map, so.
Oh, well, okay.
The
But-
areas in question are, with the new application and the backlot, are the A1 areas.
Oh, good. And in that case, it's still, yes, technically it's quite an error, but it's not as bad an error as if this was the R1B. But I can even add to that. No, I won't. This is sticky enough. So, again, how it kind of switched over into a CUP, I don't know, but I can tell you, no, Mr. Simpson's correct about the law on it. Number one, non-conforming uses are not supposed to be expanded. We've done that because we don't want to harm the guy that we've allowed to be there and is in fact just following up. Are these things been in violation from time to time? Yes, but it's been done trying to protect neighborhood, protect property values, and so on. And that's why we've done this. And that's why, even though it probably shouldn't have started, we've allowed it to continue because we don't want to harm any of them. And as some have said, they see it as a good thing. Obviously, if you interfere with noise and whatnot, that's not going to be seen quite as good. So, short answer, I do agree with Mr. Simpson on that. I think we've got more more factual matters to consider, because I happen to also believe this back lot was not included in 2014. So, number one, it's not a matter of whether it was appealed in 2014. If it was not included, then there was no appeal period. And whenever that's realized, I think it can be enforced, and that's the reason for Joe's letter. And I think Joe's letter would have been fine if it was another 5 years down the road. If it was included, it's included. It doesn't matter about their interactions. It doesn't matter about, amelioration that Mr. Sweeney performed. If it was not included, it was not included. And I just happened to notice at our September last year meeting, I believe it was then, it might have been in Joe's and my discussions or something, but I had said, I know very good and well this property was not included because they didn't have a survey of it. And we can't approve something without a survey. We got to have an ownership, and that was all in question. And that, I don't think, was ultimately done until maybe last year. I'm not sure about that part. Well, guess what I found in the application? Well, what paragraph was it? There's no legal description of it. Ownership is uncertain. And Sweeney is using this area without consent of the owner, whoever that might be. Ultimately, he did get the property. Ultimately, he did get it surveyed. But we couldn't possibly have approved it if, in fact, those questions were up in the air. The application says, as been pointed out by Joe as well as Simpson, it was marked for material storage, not for parking, not for anything else. In fact, the application talked about all the trucks being kept in a building of some sort, not in the back lot. So, yes, those were problems, those are obstacles, but we have others. And I think, along with Mr. Hart, no, equity is not part of this process, but by golly, we've operated with a whole lot of equity through the years. And I'm not really going to sit here and say we stop that tonight. Even though Bruce is right, legally we probably should. Because the fact is, we've allowed some of this. We've tried to maintain property values and all that through the years. And in fact, that's pretty much the only reason Mr. Sweeney even has the operation. Because people have had similar operations for years prior to this. Now, I've rambled way too much. I hope I've answered some of those questions, and if I'm wrong on something, Joe, please point it out.
I would disagree slightly, and you may have to respond to my comment, but landscaping business aren't listed in the zoning ordinance. And as a matter of precedent, they have been allowed in A1 over the years, not only on this property, but many other properties, but as conditional uses, not as non-conforming, but as new conditional use permits, they have been allowed in A1. They've been considered, prior directors have made the interpretation that they're ag-related businesses, more appropriate in an ag zone as a conditional use. It's not specifically spelled out, but they're not specifically spelled out as permitted uses anywhere, so that's always been kind of the interpretation.
And that's true. I'm glad you pointed that out. That is true.
So, I mean, I know there's 2 or 3 others prior to this one, since I've been at the Planning Commission, that we've approved as conditional uses, as new uses, not as just changing use on a property. So I guess that's the one thing I would say, that we have allowed them because they're not listed and because that interpretation has been made. But
and that is true. I agree with that. That's a good clarification.
Did I have one?
Yeah, but I can bring that up. Thank you. Do you all have questions, discussions?
Plenty of discussion. Plenty of discussion.
No.
If I could point, because I know I've probably created more questions than I've created answers, and I apologize for that. But as far as how all these things work together, again, it was not included, I'm just utterly certain, in the 2014, so I just simply think the appeal has to be denied, and Joe has to be upheld on that one. The other one, regardless of whether it started out truly as a non-conforming use, the fact is we've treated it as a conditional use permit all these years, and I think the front application simply ought to be addressed on its merits, not because it may or may not technically satisfy. That simply has not been the way we've treated this, and I think that would be unreasonable at this point to treat the amendment application up front. But again, the other one was not included. I can't see how we can say otherwise. I think Joe's correct on that.
I want to word this very carefully, but Charlie, I respectfully disagree with you. I think you have to look at the intent. We've heard a lot this evening. To your credit, Joe Kane's always put in the middle, agreed. But I will say so are we. So we're sitting here today, and it's business is what this boils down to. I'm well aware that you guys don't get along, okay? That's obvious to everybody sitting in this courtroom, and probably our courtroom. Is this a courtroom? Yeah,
Yes,
it's a courtroom.
yes, we've been advised, we are in the courtroom.
Sounds good to me. All right. I'm well aware that everybody sitting in this courtroom knows, and probably everybody in that area knows as well. So that's not uncommon, but that's not why we're here, is to address why you don't like him and he doesn't like you. What we're here to address is whether the appeal is to be granted or not. We understand you've put considerable amount of money in that. That's not to be addressed either, and I don't mean that in a bad way. I have my own business as well. I understand, okay? But when you do those things, the board has recommendations. You followed the recommendations. Congratulations. And I don't mean to sound callous to that. But that's really what it boils down to. To me, it is the intent of what the 2014 meeting was had. Whether or not the backyard, and I wish the term yard would have never been used, and I probably will never use it again in my life because of this, but whether or not included a parking lot. And Joe, I do have a question for you, because I wrote something down. I'd like clarification. In the 2014 meeting, you had the discussion, or they had the discussion about screening in the back. Mm-hmm. If you look at the development plan, screening was added around the salt dome and back where the trucks were. Screening was not added by the railroad tracks because I believe it was the staff recommendation at the time that natural screening was already in place. Is that correct?
Yeah. Natural screening was in place. I don't know if we even considered screening there.
Unnecessary.
Just because the railroad was there. The only screening we really considered at all was to the north. So.
And the screening was put in place because?
I know the property owner of the owner of that farm was at the meeting, and it was just to address, because that was such an open area, just to provide some buffer and screening, visual screening from the street as you're coming down the road and from that farm, just to block that view.
So the area was definitely considered.
Yeah, screening was considered. I can't address that back part because, as Charlie said, it was kind of overgrown. I think that ownership was ambiguous. I don't know.
I mean, their own application says that. Just because my feeble memory thought it remembered that, don't hold that against it. It said that in the application.
So the appeal this evening is to verify whether we agree with Joe's letter or whether to overturn Joe's letter.
Correct.
Nobody's going to be popular when we leave here this evening. And that's not what this is about. It's not a popularity contest, if you will. It's the unfortunate ability to have to make a decision one way or another. Somebody's going to leave mad, somebody's going to leave happy. I have a feeling we'll probably see everybody again at some point.
Yes.
But it's hard to deal with. And what we have to do, and in the staff recommendations today, there are two words that stick out to me, which is or reject the zoning administrator's letter and make a finding that the use rear yard was contemplated and approved, or approved, either one, okay? Contemplated, that's where I'm getting at with the screening. Do I believe it was contemplated? Yes, I do. The approval part of that, as far as material storage, parking lot, things, obviously it's being used as a parking lot. It was directly after that, leads me to believe that it probably was. Do I feel that way? I'll tell you in a minute, but we have to make a decision one way or another. And that's what it boils down to, is was it contemplated at that time? Thoughts?
I agree. My initial reading of these minutes and the back data, I do recall that we had this meeting on Zoom. We established that they needed to come back and say who owned the property. He came back with that. Then we had more discussion and meeting, and we told him that he had to have what is the word?
Screening.
Screening around that area. And I also will ask you all and the board from now on, when we make motions, we're going to make motions to say plat specific or description. We're not going to say yard or the backyard or the fence or the garage, so that we don't have this situation in the future.
But to go to what you're saying, I made that motion. And we did. I did specifically say the backyard. We were in reference to his complaint that I asked for that screening to be put in. So,
And it's,
I mean, I'll take that. That's,
Well, somebody's got to get it started, and somebody has to make the motion in order to do that. I'm sympathetic, I am, to neighbors not getting along. I wish you guys got along better than what you do. But that's not why we're here. We're here to decide on the appeal. I make the motion that we reject the zoning administrator's letter. I make the finding the rear yard was contemplated and approved for the current business use in the 2014 conditional use permit.
I'll second it.
we have a first and a second. I'll entertain.
All in favor?
All in favor? Please vote.
Aye.
Aye.
Aye. We approve the rejection of the zoning administrator's letter, and we'll proceed with the contacting Mr. Sweeney from here forward. Mr. Linder, Robert Linder, are we discussing?
There's another one. Yep, there's another one.
The 20, the
But it's
39.
listed as,
The agenda has Robert Linder between the two.
Yes, we're still, that one,
okay,
All right.
thank you, then we can move on. To S 2021-39.
Thank you. This is for the same project site requesting a conditional use permit to use a portion of the property as a parking lot, specifically on the north side, kind of jutting out from it. It is in the A1 zoning district, and the total acreage of the site is the 3.889 acres. This is the same photo we've been seeing. The property in question is the northernmost, almost like the top hat portion is how I've been kind of referencing it on my own time. But that top hat portion just north of the buildings and kind of furthest from the railroad track. So I've circled it there so you can actually see what I'm referencing. The applicant is seeking to establish a gravel parking lot similar to the existing parking lots that are throughout the property. This is the kind of development plan. It's the shaded area. They are staying out of the floodplain area that kind of corresponds to the creek, and the shape kind of reflects it. And I have a zoomed in portion with some colors that I tried to pick colors that would be kind of easy to distinguish what I'm referencing. So the shape is outlined in the orange there, and then there is a fenced in area that is the light blue and a landscape buffer that is the darker green. So it's a small area. It's kind of, I tried my best to distribute what it was. We've kind of already gone over the uses for parking and everything like that. The projected use for this would be to operate it's about just over half of an acre portion of the property as a gravel lot for staging of vehicles prior to the day before the work day was getting going, just kind of having things available for general use. And I believe employee parking is more in the kind of southern portion that is kind of catty-cornered to the proposed gravel lot that is marked with parking spots and turnstile or turn movement property, but I may be mistaken on that one. The landscape buffer is parallel to Paynes Depot Road, and then kind of has that 90-degree turn to it, so it's just kind of something to prevent any additional noise to Paynes Depot Road, and there would be no access through that portion. It would only be through the existing attached portion, and it would not have its own direct route to Paynes Depot Road. These are, oh my God, that was, I do not appreciate that. Kind of burst my bubble on my order stuff, but these are just the findings here. We've previously determined in previous conditional use permits that parking areas are an accessory to the previously approved business, and it'll have lower use just because of it being a non-retail specific business. Instead, it's just for planning and staging as opposed to having customers coming in and out of the property. Proper screening would ideally, and it has been, the landscape ordinance is in place to protect surrounding property owners in order to ensure that they have some mitigated light and noise from the uses on the property. And the development, because of the size, we did determine that it would need a development plan because it is about twice as large as the one that was approved in 2020, I believe, and that required a development plan. So it was under the conclusion that this would also require some type of development plan in order to properly understand the species and the grading and all these other important factors that we use in the development process. Staff does recommend approval of the conditional use permit subject to 6 conditions that are listed on the board. The first 3 of which are the typical ones we see for a conditional use permit, subjecting the property to zoning ordinance and subdivision regulations, complying with other federal, state, and local regulations, and that the conditional use permit would become null and void upon the sale or transfer of ownership of the project site. Condition 4 references the requirement of a preliminary and final development plan from the planning submitted and considered by the Planning Commission prior to any construction or grading on the project site. And the 5th one is a contingency saying that the applicant shall not use, I'm sorry, I reference yard a lot in this, and I know we wanted to stick away from the word, to reference that northern portion of the property for the conditional use until the development plans have been submitted and considered by the Planning Commission, and that they are also subject to the previous conditions of approval associated with the S-2020-20 conditional use amended situation. That's all I have. Do you have any additional comments or questions from
Thank you. Do you have questions, sir?
No.
Would the applicant like to speak to us again?
Thank you, Madam Chair. Be happy to answer any specific questions that the board may have. I believe we've already outlined essentially what the intended use is. That is for staging of vehicles, similarly to the way that the backyard is being used now, but also by doing so that will alleviate some of the pressure on that backyard and that back lot, and so it will be the same type of use as that is currently being used for back there. I believe staff has adequately pointed out the main features of the application itself and the use pertaining to screening and flood plan, et cetera. I also want to point out, I don't frankly know whether there is any objection to this conditional use permit here tonight. To the extent that there is, to the extent that there may be for Mr. Plunkett, simply would point out that I believe what he's already testified to tonight is essentially that I believe he said something to the effect of that the sounds that he hears on the back lot wouldn't be heard by the people on the other side of the property. I simply asked the board to observe that the converse would be true as well. I don't believe that this use on the northern end of the property will negatively impact the property up to the south of the railroad tracks, and instead would alleviate some of the pressure that he's complained about. Be happy to answer any other questions that the board may have.
I don't have any. Thank you. Would anyone else like to address?
Thank you, Madam Chair, members of the board. For the sake of brevity, I'll incorporate by reference my statements and arguments made during the course of the appeal. As I indicated, they apply with equal fervor here. I would, though, ask you to look at the reality of this particular situation, in that this is agricultural land, zoned A1. No one disputes that. And this business keeps growing and growing. Can be a 24-hour operation. And I would ask you to imagine yourself living next to the beep, beep, beep all night long when you're living in a single-family home in an agricultural zone. And this property, I applaud Mr. Sweeney's success, but he's outgrown this location. It's gotten too big and it's going to get bigger. He tore down 3 houses for parking in 2020. He came before this board. Now he's coming for adding additional land. It's going to get bigger and bigger, which is wonderful for him, but a nightmare for the people, the Plunketts. Now, you say, well, that's just only one couple. And I'm not saying you say that. They're the only ones that have objected. This is not about them in terms of the controlling law, and obviously you all can't make a decision on that. But this is growing. It's going to keep growing. He'll be back and growing again, and then Mr. Plunkett, if you keep approving it, he'll either have to suck it up or eventually move, because this is an industrial use. It needs to be in an industrial zone. It needs to be in an urban area, not in the agricultural area for which a conditional use is not even enumerated. Now, I will amplify on a couple of legal points. The fact that this board had made previous decisions in error to grant conditional uses on property that wasn't zoned to allow for it doesn't mean that you can keep on doing it. I mean, and I'm just making this for the record, please understand. Don't take offense in what I'm saying. This is for the record, because I believe strongly in what I'm saying, and I guess we'll find out. But the fact is, the fact that you keep on making the same mistake doesn't mean you can't be corrected at some point. I mean, imagine if somebody gets violating laws. Well, you can't prosecute me because, you haven't prosecuted anybody else. Everybody else, what's the purpose of the law? At some point in time, somebody calls your attention to it, and the law says you can't do it, then you got to stop. And tonight, I'm asking you to stop because I know what the law says. So I'm asking you to deny this conditional use permit on the basis of it's getting too big, it's a nuisance. A conditional use permit, according to the statute that guides your decision, is to allow for integration into the community of uses which are specifically named in the zoning regulation. Of course, that's a fail. Which may be suitable only in specific locations in the zone if certain conditions are met. I don't see any conditions about limiting hours of operation. I would ask you, if you're going to approve it, to put our limitation on hours of operation from 7 a.m. to 7 p.m. And if he wants to operate a snow removal business, he needs to relocate that someplace else. I don't think Mr. And Ms. Plunkett ought to suffer from this growing business right next to them. I think it's only fair and equitable, if you will, that he locate the snow removal part of all this someplace else. And finally, I will just say this. No one disputes the zone in place is A1, and part of it's R1B, but apparently, going by the zoning ordinance that Joe put up there, it's A1. It's not specifically named for this conditional use. It's a use that got granted through ERA several times. That makes it a non-conforming use to the zone that it's in. That's not in dispute. And because it's a non-conforming use, as a matter of law, it can't be expanded. I make this for the record. I appreciate your all's attention to my position and my argument. Be happy to respond to any questions you may have.
Thank you.
Thank you. Madam Chair, I would like to, I believe it's incumbent upon me to, for the record, respond to a couple of the legal arguments that Mr. Simpson has made. First, I would object to the speculation that it's going to get bigger, because whether it's going to get bigger or not is simply not in front of the board tonight. The question is whether you're going to allow the conditional use of the lot in question for parking. Speculation about what the landscape market may do in the future or how well or poorly Mr. Sweeney and his company are going to adapt thereto simply beyond the scope of this board's inquiry tonight. I'd also point out that we are talking about an A1 or an A1 zone specifically for this particular use. And as Mr. Kane has indicated earlier, in his earlier statements, landscaping businesses and snow removal businesses, my understanding, have been granted conditional use by the board in the past, not just in this particular case, but in other cases. And while Mr. Simpson may disagree, the fact is that the prior interpretation of the zoning ordinance does matter. And so if the board has interpreted the zoning ordinance in a way consistently over a number of years and has allowed landscape use as a conditional use in agricultural zones, then it would be arbitrary and capricious and therefore would be a violation of Section 2 of the Kentucky Constitution for this board to now arbitrarily decide we're not doing that anymore. The fact is that the past interpretations and applications of this code do matter. And it would be arbitrary for the board to now simply, as I've used the analogy a couple of times tonight, move the goalposts with regard to what is permitted as a conditional use in A1 zones. Finally, I would point out that an arbitrary limitation on the number of hours would be a mistake. It would be a mistake for a number of reasons. As anyone on this board certainly knows, snow removal business is important, it is integral, it is critical, and snow and ice do in fact occur at all hours of the night and day. Mr. Sweeney can give some specifics if the board would like about how common an actual snow and ice event actually is and an approximation of how many days over a snow season they actually operate as a snow removal business, therefore how many times they are there in the night. I believe that may be relevant to the board, and Mr. Sweeney would be able to address that if the board so desires. Thank you.
I was curious about that.
Yes. Give us the statistics.
Yeah.
All right, so as Mr. Harp said, we do operate a commercial snow removal business, which you all know. So we're in a very strange snow removal market. Our average inches in this area is like a 14-inch market. Well, if you look at last year, we had a pretty intense February. Everybody probably remembers there's a lot of rain, a lot of ice, a lot of snow. So it was like a 17-day span. So that is a very important part of our business, but we do serve hospitals and logistics and power companies, utilities, different things all across the area. So we actually don't perform snow removal at our lot though. So our lot is used to refill trucks as they come in and out. They are equipped with safety equipment, different things like that. So a year like last year, during that February 6th to about 17th, somewhere in there, we were in there quite a bit around the clock, loading trucks, taking trucks, moving in and out. So we were in a lot. The year before that, I think we had about 2 inches of snow. I think we might have had 2 or 3 nights we were in. You can go to the year before, you know, it varies. It's a seasonal market, but we're at a 14-inch average. So that means we're going to come in and out 20-something times throughout the season of nights if we get an average winter. And then a lot of the trucks, every truck doesn't come to the yard. We have satellites throughout the cities that we work in. So a lot of the trucks, they disperse and then they'll never come back. It's only kind of local market trucks that actually hit the yard. So as he said, our fleet has grown, but not every truck comes through it throughout the time. Happy to expand more if you would like, but
That's good.
Thank
you. Do we have anyone else that wants to speak? Yes.
The snow removal thing, something he hasn't stated, he owns property that's in I-1 in Frankfurt. And Joe, actually at one point we had a discussion and he had talked about maybe possibly talk to them about moving the snow removal to Frankfurt. I shouldn't have to be up all night when it snows. Would you like to be up all night when it snows?
I wouldn't like the relationship that you all have as neighbors at all. I really
No,
wouldn't.
I don't like it either.
Yeah.
I'm not the cause of it.
But we're not here for
Well, you brought it up. My point is, would you like to be?
No, sir. You asked me how I would like to live there.
No, you said you didn't like the relationship we had as neighbors, and I said I don't either.
That's enough.
Would you like to be woke up all night?
We're not. I appreciate your comments.
Rhetorical.
Do we have discussions?
No. I don't.
No, I mean, he's talking overflow, so this would help some. I'm sure they'll expand some trucks to go with it, but farther away. I have no issue.
What's everybody looking at me for?
I'll
Look
entertain
that
a
way.
motion.
I did look that one.
Do you want-
Charlie, do you see any more contradiction in this happening from what we're already approving as far as why we should not expand farther along with this? Or is this just, I mean, an overflow of what's currently there?
Well, as I said earlier, strictly speaking, you are supposed to approve conditional uses in areas where they are listed and where they can be integrated into the neighborhood with appropriate conditions. And frankly, I think the only reason this ever started was because there was already industrial property there, not because it can be properly integrated. Now, is that a path, I won't call it error on the record, but is that a path you want to continue? If that's reasonable, then we're probably going to have to defend it in court, and this is not the biggest problem we face in doing so. So, on the other hand, I don't think there's any question conditional uses are not supposed to become the dominant use in any area. They're supposed to be something that can be integrated. Well, you can look at the map for yourself and see if that's going to happen, especially as it, you know, as it's growing this time, not as it's going to grow necessarily in the future, because we don't know that. So, yeah, this is consistent with what you've done. Is it technically correct? No, of course it's not. But we haven't been for, you know, I don't know when we approved the first thing on this thing. It was well before Mr. Sweeney came along.
But you say it's consistent.
Well, I mean, it is, but, and I guess the only other thing would be is any conditional use supposed to be this basically dominant of its location? Well, that's, if this is not, you know, making this, you know, worse, or if it's not already way too far, then, you know, it's just, we do this kind of thing all the time. If it has grown too big for the area and it shouldn't be doing it like that, well, then that's a different animal.
I'll entertain a motion.
I'll do it. And y'all can just take it from there. Reading over the staff recommendations that were given, the 6 recommendations, also the discussion of a landscape buffer. I saw that the staff has recommended approval for this. I'm not hearing anything that goes against that, other than, of course, it is the growth, but it is consistent to where we're at. So I will recommend that we approve application S 2021-39 at 390 Paynes Depot Road for accessory parking lot based on and including the staff's recommendations and conditions.
Second.
I'm sorry, Rachel?
Yes. I have a first and a second. All those in favor say aye.
Aye.
We've approved 2021-39. Thank you. So then that moves us on to.
Appreciate y'all.
Thank you.
For showing me that the zoning board doesn't work.
Thank you, sir. We'll move on to the new application of S 2021-41. This is, thank you.
Thank you. This is S dash, I forgot. Keep going, I forgot. This is S-2021-47, which is a conditional use permit for a public and private park and recreation area located at 2 parcels off of Porter Road. One of them, which is addressed is 877 Porter Road, and the one beside it, which is not addressed, at least not noted as addressed, but the parcel numbers are up there. Unfortunately, they're not numerical, so I couldn't do 1 and 2 very easily. So parcel number 1 is identified as 127-00-002, and parcel number 2 is, I have identified it as the address location at 877 Porter Road. It is zoned A1 agricultural and is surrounded by A1 agricultural areas, and it has a total acreage of 15.08 acres, with parcel 1, which is the non-address location, having 5.14 acres, and parcel 2, the address location, having 9.94 acres of land. Staff does recommend continuation, and I'll kind of get into that one. This is an aerial shot of the site. We had seen this one last month that included the portion that kind of cups the west and northern portion of the property. That was a 67-acre portion of the property that at the time was under, to the staff's understanding, was going to be owned by the property owner, but since then the land has been sold, and as a result, the conditional use permit or any kind of use permit on relating to this would need to be re-reviewed, because that portion of the property made up 81% of the approved land mass for the use. So since then, we've reduced it down to 19% of the additional one, or as stated previously, it's 15 acres of land. Oh yeah, I can speak up. It's fine. Yeah, just for Jay. I will continue to speak up. This is a topographical layout of the property, so it's an aerial shot. Jay, our lovely GIS man, did all of it. It's difficult to see the topographical lines, but they are every 5 feet of vertical difference. And as you can see, there's a pretty significant volume of it. The home sits below Porter Road, and we did drive the Planning Commission vehicle down that road, and getting back up it was pretty challenging given it being a 2-wheel drive vehicle. So it is a pretty steep portion of the county already, and then the site itself is also emulates that layout, or that expected topographical layout. So any construction in the area outright is probably pretty challenging, but we'll get into that. This is the submitted document from the applicant. It was turned in on Wednesday at 11 a.m. I had requested previously that it turn in on Monday at 12 noon for proper board review and staff consideration, and unfortunately that was not available to us, and we received it 48 hours late. So given that it has given the board 36 hours to review this properly and for us to contact necessary parties, staff has some concerns on the delay, and that is partially why we are recommending some type of continuation of the project. The project does show a pavilion. Actually, I have a labeled document. This is just it imposed on the property that is existing. Anything that is outlined in purple is an addition to the property. Anything that is outlined in blue is an existing structure or feature on the property. So the existing pieces are the driveway, the home, and an accessory structure, as well as a couple supplemental driveways that just kind of gently jut out from that one. But beyond that, everything else that is in purple is proposed additions by the applicant. The applicant has requested 5 glamp sites on this location with a pavilion, a parking lot, a separated bathhouse, a natural playground or a playground of sorts, and a pool, as well as you can see there's a loop for it and kind of interconnectivity throughout all of it. They are requesting an additional entrance off of Porter Road, and we can kind of see that from there. They're adding, as I kind of mentioned and kind of go to, they are interested in adding glamps to the site. So this is taken from the website that I was sent when I was requesting information on what the appearance would look like. This is kind of a model of it. They are a company that is in Colorado, which is just a fun fact about it. I guess Colorado really likes that type of thing. But anyway, so this is a canvassed property similar to like those types of rental graduation tents that you would see. At least that's how I saw it when I was looking at the skeleton breakdown. It's a it's a tent-like canvas cabin situation with on a floorboard that is typically shown as being in wood, but I would assume that would be on other properties as well. There are 5 of these located on that loop portion there. They're located in a lighter purple outlined in the darker purple, so they're placed kind of around the property in existing portions and et cetera. They've requested 5 of them, and staff believes that if the board moves to approve it, that they be limited to 3 of them with the pavilion given that this is a very atypical request for the area, and previous applications for similar things are difficult to gauge a market for. They're much less mainstream, at least when I've been doing a lot of research for it. And so staff is recommending, if the board does approve it, that they be reduced down from 5 to 3 plus the pavilion space. Each of these can hold about 5 to 6 individuals with them, so that would allow for, instead of being the number that I had on here, instead of having 38 individuals on the site, they would be reduced down to 26. So it would allow for proper understanding of the market. And then if they were interested in it, staff has included a condition saying that if after this a year of active reservations and other interactions with the site, they could return and request that the site be expanded to the full 5, so adding the 2 more additional glamp sites to the property, thus bringing it up to the 38 individuals that they're interested in adding in the property. This is just an interior shot of them, and I'm just going to kind of use as a holder. So this is just a shot of what it is like on the inside. You can see that they are very similar to, again, I keep saying graduation tents, but that is just growing up and everything. That's just kind of my main point of reference. Staff has a series of concerns about the property. We're concerned about the density of units on the project site. Parcel 1 does have a housing credit and parcel 2 does not. So parcel 1 is the unaddressed location and parcel 2 is the address location. Staff put a recommendation in there that any structure that contains what would be typically features of homes, such as restrooms, kitchens, and bedrooms, beyond an area that has a housing credit. So if it is permitted use, the staff does recommend that it be placed on the parcel that does have an available housing credit and not the one that does not have one available. Staff is also concerned about just the traffic in the area. We've heard multiple comments from various concerned citizens that having an active area like this with reservations and having 26 individuals, they're not coming just popping up, they're having to drive down the road. It's a narrow road and a hilly kind of turny area, and people are concerned about traffic safety, and they're also just concerned about the individuals that would be coming to this site. They don't know them. This is a very small area. They don't want strangers kind of getting onto their properties, threatening their livelihoods, interrupting their ability to use their properties, and they're very concerned about that, as well as for the safety of their children and other individuals on the property, making sure that trouble isn't finding them in their homes when they're trying to stick away in that area. Let's see. Unable to get a proper image of this view from the road, but since it's downhill, you kind of are looking in and down into the area, so light and sound is coming up and through. And so that's another concern of people from the area, saying that it would be adding all these individuals to the area and adding their activities would add light and noise to the property, which would be atypical of the area and would require significant landscape screening besides just the natural existing stuff that is shown in this site here. So as you can see, some of these are pretty exposed, and people are concerned about the viewing individuals going on retreat or just action in the area. They are generally very concerned about that type of thing, as I've said many a time. Additionally, staff has concerns about hunting in the area. Hunting is, for me, I'm not used to it. I grew up in an area that doesn't have a lot of hunting. It's mostly suburbia, but understanding the region and the regional preferences for hunting, people are concerned about those who are hunting around the property and individuals going onto the property, trespassing, not knowing that they're trespassing, but trespassing nevertheless and putting themselves into significant harm's way to be injured, if not killed, by a hunting incident. And so there are many concerns about that type of situation happening and those types of detrimental ordeals occurring. In light of all of these things and kind of considering everything, staff does recommend a continuation, primarily due to the lateness of the final report. That is, that's an inappropriate amount of time for the board and staff and other government bodies that we consult for these types of projects to review projects and have proper consideration. We need more than 36 hours or 34 hours that we were given to make these proper considerations, and staff believes that while that shouldn't, the emotionally chargedness of it shouldn't be a defining factor as to why it needs to be continued, it needs to be a factor that is considered in that process. If the board does move to approve the conditional use permit, I have 14 conditions on this one, many of which are from the previous application heard in November, and I'll kind of run through them. The first 4 are our typical ones for conditional use permits. Our next ones are that a development plan must be submitted prior to any action happening on the site. They has to be approved by the Planning Commission, and a final development plan would need to go through before anything could happen. The pavilion must entirely be on parcel 1, as defined, as it is the only portion of the property that is eligible for housing credit. The glamp sites are reduced to 3 instead of 5. After 1 year of continuous active rental by guests, the applicant can reapply for an expansion of the number of units from 3 up to 5, unless, 3 up to 5. We're going to end that sentence there. Any new entrances need to be approved by the Kentucky Transportation Cabinet in the area. I'm unsure if that address, the access point off of the unaddressed parcel has a existing one. I was not able to find one in our plat record. That does not mean that there isn't one, but any new additions to the road and driveways to the road must have approval. They need to pave the new driveway, or at least the existing driveway, so that people have safe ingress and egress from the property for safety vehicles, for individuals and guests, for really necessary accessibility of the site. They shall install a barrier around the perimeter of the project site, defining where the property is and is not, and where you would be trespassing. It needs to be something that is well defined in staff's opinions, but that can be obviously disclosed further in the development plan processes, or you guys can add specifics to what a barrier means. They need to register the venue with the Georgetown-Scott County Revenue and Tourism Commissions, which I believe has already been done. They need to have written approval from the building and permitting offices, as well as the fire marshal, prior to any construction that would allow for these types of things in here. I'm sure the state of Kentucky has some very specific logistics on residential cabins and tents to make sure that they are not fire hazards. Site activities must cease after 10 p.m. That was listed initially in the first application, and I just want to reiterate that noise and sound is really detrimental to livelihood in the area, and staff believes that having some type of control, or some type of saying, hey, after this point, sorry, you got to stop, is appropriate, and it reflects a lot of the concerns that I've been hearing. And the final one is that septic and food operations must have approval from the health department. So at any point, I mean, we previously had seen the application, but they at one point was intending to have a brunch option or some food options available in a kitchen. And those things need to be brought up to health code, and the septic tank needs to be brought up to health and safety code and sanitary code, as well as all other utilities need to be brought up to the standards that are set by the county and cities and state of Kentucky and federal government. So I'll kind of end that one on that super positive, happy note about septic tanks and health code violations, but that is all I have, so.
Quick question, just, you list 5 on the application as far as the glamping sites, but the map actually shows 6, I believe.
Yes.
And that may be because you didn't have enough time to review everything, but.
Yes, that is a portion of it. I'm imagining that some of these are proposed locations as well, where 5 of them would be used, and one of them is just kind of like, oh, if this one doesn't work, maybe this one works, but I can't impose my opinion on why there were 6 depicted.
All right, thank you.
Is there any other?
You all have any questions?
No.
Would the applicant like to speak to us?
Hi, Sheeta Values. So just want to explain to that why it was a late turning in is because my husband is in ICU. So I am dealing with just transporting back and forth. Those pictures, images were just trying to clarify of an idea of what the glamps will look like. Also, the situation with them driving, they came down my personal driveway, which would not be used for my clients. You know, if somebody's coming out there, they have a separate entryway. So it's approved already, has an address. So we would do the proper road corrections to make our, you know, the drive safe. I'm trying to think, I'm trying to collect everything that's going on. As far as glamps, we did say that we can push back to 3. That's okay with me. Noise-wise, can't be as loud as my girls and their 10 girls, friends at a birthday party. So, I have children. So I'm definitely not going to bring harm's way to my children. I'm not going to bring, that, all that's going to be separate. That 5 acre is paid and bought. That's where the activity will be put on. I'm working with a certified architect, so they are making proper arrangements. I have a gate security that has a firebox lock, so nobody is not going to just enter in and out of the property. You have a Love's truck stop that's 1.5 miles away, and you have truckers, so you have random people already that walks Porter Road, just strangers. So I don't see any, what my business would bring something like that. It's simply a luxury for people to enjoy, to relax, nothing else. I have hours set, so I would like to get sleep too, so, yeah.
I have a question, because we've done a lot of venues for weddings and this and that. So she has proposed a 10 p.m. Noise curfew, which we do quite often. How would you address that as far as trying to show a movie at 9? Would you just move the time up, or would you have to do away with those because of when the sun sets and it gets dark? How would you handle that?
If it's starting to be where there's a complaint where the noise of the screen is too loud from the movie projector, which I've had already held outdoor movies for friends and family. Never heard a complaint whatsoever about it. But if I do see that there is a complaint about that and it's a problem, I would gladly put that aside.
Because I see you've actually worded it as site activity.
It is, yes, it is put in there, yes. It's like a movie,
right?
so a movie lasts, an hour, hour and a half.
So you just move it up, that's
Yeah.
what I was asking.
Yeah.
Okay.
All right, do you have any other questions?
Yes, I do. Maybe I missed something, but when someone calls to make reservations, do you have a screening process that how do you know that these are good people that's going to be in that area, because they're probably going to be strangers to this area?
Sure. Well, it's basically like you checking into an Airbnb, a hotel. They don't know, they don't screen their customers when they coming in and booking. So it would definitely be like, they will book on site. They'll put all their information in. Of course, they have to sign a waiver, before entering on site. So, just a standard check-in, just like any hotel.
What would your alcohol policy be?
I'm not serving alcohol. Okay. And if I do, then I'll have to get the proof.
But if you saw that,
Yes.
you would still monitor the
Yes.
activity?
Yes,
Okay.
yes.
Thank you.
Thank you.
Do we have others who would like to address?
Good evening.
Good evening.
My name's Irwin Cobain. I own 205 acres off Porter Road, right after Love's Truck Stop. I own that jointly with a son of mine, Mark. We bought that property back in September of 2020. We bought property up there because it was rural, it was quiet, and we enjoy it up there. We're in the process of building a barn dominium on it, which is why I'm in the clothes I'm in today. Sorry about that, but I just left that project about 5 o'clock or 4:30 today. But personally, we're against, and I can speak for my son here as well, we're against further commercialization of that area because of all the reasons everybody else has mentioned, and I believe you're aware of. The additional noise, more traffic on what is already a pretty dangerous road right after you leave that truck stop. We don't really need that up there, and need strangers in the area, and which adds to other problems of theft and everything else. Basically want to make my feelings known that I'm entirely against what's planned up there. So, thank you.
Thank you.
Excuse me, your name again, please?
Pardon me?
Your name again?
Cobain, C-O-B-A-N-E.
And first name?
Irwin, I-R-W-I-N.
Thank you.
Okay?
Thank you. Do we have anyone else?
So which is his address on
Good evening. My name's Joshua Hurst. I bought the 67.7 acres from the Salyers, so I now own that site. And I wasn't aware of the meeting until today, as well as what was on the agenda. I have some concerns due to the size of the glamp and also some concerns related to the noise. And based on the proposal, from what I read, there was another proposed entrance, and it mentioned a 300 feet requirement between entrances. My parcel has road frontage, but I haven't applied for an access to my parcel at this time. I don't know if this new proposed access point or easement is going to affect my ability to get access to my parcel. So that's one of my really big concerns, is that most of my land sits behind this. So then I have, I've heard from other neighbors that I wasn't aware of that have concerns about it as well, noise-wise, and I'm sure you will as well. I bought the land to hunt and to eventually build a house and to farm. My concern about the ability to hunt, which has already been mentioned briefly, is that will this, if approved, will this affect my ability to hunt my own land? Is there going to be a safety issue? There's a proposed barrier that must be built. How big is that barrier going to be? Are people going to be going into the land unknowing? I mean, I'll put signs up, and I'll have a fence, but how big of a fence is it going to take? And then the outhouse, this proposed approval is for 15 people. An outhouse with a septic system for that, just the 15 people. I mean, if you see the 5 glamps, what's the water quality effect going to be? You got Little Eagle Creek there. It's not too far on the backside of the parcel. And I'm sure that's to be determined. But these are just concerns that I have, just being honest and open about it. And then, based on what I see on your website for conditional use permits, does this even fit the criteria? Because I don't know what we're calling it. It says that there's allowance for a public or private recreational use. This is a commercial recreational use. And I'm not a lawyer, but I'm just looking at it. This land that's zoned A1, does it allow such a business? Or would it be a non-conforming use? That's my question. And then if a conditional use permit is approved, what's the appeal process? This is all new to me. I don't know. The extent of the operation is my concern primarily. I knew that, something was in the works, but I didn't know it was going to be this big. And then, let's see, if you'll bear with me for just a second. Primarily, I want to state that I want to be in good standing with my neighbors, including the Salyers. So, I want to do with the majority what's best for the community. So, I appreciate the opportunity to speak. If I can get on record my address to receive future notifications for decisions, can I do that? Okay, all right. Thank you.
Thank you.
Can
Thanks.
Charlie address them?
We need your professional opinion.
I think I'm out.
She's on answer.
Oh, she has the answer.
I was just gonna, for the conditional use side of things, when we say private and public, like park and recreation area, private recreational areas can include a commercial thing. So it would be like an RV park and an A1 would be some type of private recreation area, but even though it has a commercial side, because you're paying to be there, so to kind of make that understanding.
Thanks.
This isn't an
clarification.
but yes, it is.
Okay. You can come back to.
Prior to him signing the agreement, of selling the 67, he was aware of the glamping. I want, and I like my neighbor, but he was aware of what was going to happen and what was going on, and he was egregious about that. If he was not going to be egregious about that, I would never have sold the 67.
Okay. Thanks. Now, Charlie.
Ma'am, question.
He had several septic, and what else did you have? He had several questions.
Well, I think
Well, the main one about, is this a conditional use in that area? Well, I think public and private, public, that's county. Obviously, it's not that. But a privately run recreational area, of course, that's what this is. So I don't see a problem there. just like the, the hunting camp they've got up off of Warriors Chapel. I mean, we've got a number of things like that around. So no, I think that's appropriate. As far as septic and all that, that's health department.
Right.
We don't know anything about that. Let's see, what was it? Oh, as far as, yes, there are certain distances required, both site distances as well as absolute separation from entrances. I don't believe that stops an adjacent property. That's where they can be done, they're done. If they can't be done at all safely, well, I'm sure that's happened. I don't know exactly where you are. This road does go up and down a bit, but I can't imagine she is going to have anything, her property is going to have anything to do with interfering with your having an entrance.
Yeah, that's a state road, and that plat was reviewed by the state before it was approved. So, I mean, you'll be able to get an entrance. You can't be landlocked, so.
And their presence will not interfere with your hunting. Obviously, you've got to be cognizant of what's going on the next hill. But no, the fact that they put something there doesn't stop you from otherwise lawful use of your property. Was there any others?
Do you all have other questions?
Was that all his questions?
I live at 831 Porter Road, which is right next to Ms. Salyer's, and I see no issues. Our property meets in many different areas, and I see no issue with it whatsoever going up. I think it's great that she's trying to get something for families to do. I don't see any issues as long as everything is by code, and which I'm sure it will be like that. So.
Your name, please?
Monica Petrie, P-E-T-R-E-Y.
And be sure to sign. Oh, she already took it, sorry.
Wasn't this moving a lot closer to the road?
We need to ask that.
Yeah. It moved it forward. It moved
No,
forward.
you're not. Is there another sign-in sheet? Oh, okay. Well, I can just write it in. Did you get sworn earlier?
No.
Do you swear?
Yes, I do.
Thank you. Monica Petrie?
Yes.
That's good. I've got you here.
Okay, so I don't need to sign this one then?
No.
Okay, thank you.
Requirements, 1,500 feet back and all that.
I'm just trying to get this set in my head. I know when we talked before about where the screen would be, and it was going to be dropped down behind, and now I'm understanding that you've sold the 87 acres in the back. 67. How far did this have to move? I mean, are you having to move toward the road now with everything? Is everything staying the same? Okay. I was just. Okay, I was just trying to see what the impact would be with the reduction of
I'm glad you asked
land.
that because I had that question up in my minutes. You sold 67 acres? Now, it was 67 acres we were in here last month on. So that's right. So that 67's gone, and now you're going to be operating on the 15 for tonight, not on the other.
Yes, sir.
Oh, okay. Well, I never did catch that. Thank you.
So it's a significant site reduction, I mean, as far as the property goes.
All right, in that case, so instead of we're adding anything, no, now it's going to be 3 units where it had been 5 on the other.
Correct.
And I was moving along like there's now going to be 8. Okay, now I understand. Thank you.
That's going to be a lot, 15 acres.
It's a lot of activity, 15 acres.
Yeah, so the 15 now that's operable, that's actually that little kind of 4 or 5-sided thing that set in the crook of the big 67 last month, right? And you're the 67.
Yes, sir.
By golly, I know what we're doing now. Thank you all very much. I appreciate that.
We'll swear you in.
Oh, please don't. I could deviate at any moment. Okay.
Was there anybody else here?
Do we have any other questions or discussions?
Is that everyone who wanted to speak?
I think, as far as the staff recommendation goes, we did ask for a continuance from the staff. And I am very sympathetic that your husband is in ICU. We hope he is well. But to get to the number we need to get to and all the agencies involved, I make the motion that we continue this until January meeting. In order for people to get questions answered, they need to have answered. Maybe you can meet with them, work some things out between the three of you, or whatever you need to do. But I make the motion that we make a continuance until January.
I'll second.
All those in favor say aye.
Aye.
Excuse me, who seconded, Chair? Oh,
It
okay,
continued
Janet,
until
thank you.
January.
Janet.
Yeah.
There's just a lot of things up in the air that way.
So you shoot, Elise will be in contact with you. Is that a no? That must be a no. And then Elise, Elise or no?
Yeah, that's right. You're
We have our last order of business.
Yes.
So I unfortunately did not have it on the PowerPoint. I made it and added it and did it late, so.
That's fine.
You have the, please stand in front of us. We have the Scott County Board of Adjustment application deadline forms in front of our board member here, and it would be available online whenever it does get approved. So, yeah, I tried to make sure we didn't hit any holidays. You're welcome to double check me, but to my best of my ability, I don't, there's not very many Thursday holidays besides Thanksgiving. Yes, everything is on Thursday on the same time which is 5 p.m. in this room.
I guess that needs a motion, Charlie.
Yes, sir.
I make the motion to approve the 2022 meeting schedule.
Second.
All those
Rachel?
in favor say,
Okay.
yes. All those in favor say aye.
Aye, Rachel, seconded.
Meeting adjourned.